you, Jan. Can everybody hear me?
Yep.
I'll try a little better. Well, good evening.
Good evening.
The Constitution is 1-1 today. The Supreme Court of the United States recognized the Second Amendment. It applies to everybody. But the First Amendment didn't do so well today. Apparently, a public university can set the rules for associations that a religious group on campus cannot exclude people who don't believe in the religion. So, unclear to me how we do these things in Washington, but that's the way it is today. I heard this was a place where I could speak to people who cling to their religion, their guns, and their Constitution. That's always a good group for me. My name is Bob Young, and I'm a judicial conservative. Judging while conservative is not for the weak. It's not an illness, and there's no 12-step program to cure it, because it's simply a commitment to the rule of law. As of today, I filed my papers with the Secretary of State, and I will be officially on the ballot in November. I want to speak to you this afternoon about the role of the judiciary so that you can better ensure that the judges and the justices you elect will respect your policy decisions rather than imposing their own policy preferences. The founders thought the judiciary was the least dangerous branch, but our modern courts everywhere have been subverting our Constitution and undermining the traditional values that have preserved our nation from its very beginning. Now, if you haven't noticed, there is a war going on in our country, and the one I'm referring to isn't in Iraq or Afghanistan. It's being waged right here on our shores and in our courts. Now, each of you here this afternoon has skin in this war, and it's a war that's fundamentally a battle over who gets to govern in our society, we the people or judges. And the battle is between folks like me who believe that judges should follow the law versus those who believe that judges should make policy decisions for the rest of us. Judges like me are rule of law types who believe that judges have constitutional authority only to enforce the law as written and that laws should apply to everyone equally. Now, those on the other side of this judicial war think that judges should take sides and make policy. For example, here's how our president thinks judges should function. We need somebody who's got, and I'm quoting, we need somebody who's got the heart, the empathy to recognize what it's like to be a young teenage mom, the empathy to understand what it's like to be poor, or African American, or gay, or disabled, or old. And that's the criteria by which I'm going to be selecting my judges. And of course, he's done so after the Kagan hearing today. Now, empathy sounds good, but the president's vision of how judges should function is both radical and it's dangerous. Why would anyone's gender or skin color have anything to do with the legal merits of his case? Should a judge ever decide in favor of a party because of who he is rather than on the legal merits of the case? Almost any child would answer no, because we all understand that empathy for one party means bias against another. So no matter how nice it sounds, the president's approach is really a code for those who understand it. It's an invitation for judges to ignore the law and decide cases on the basis of their own biases. Now, why does any of this matter to you? I assume that each of you sitting here wants a judge to decide your case on the merits rather than on whether the judge thinks you are the kind of person worthy of his empathy. However, there are very few remaining rule of law judges, and we are all under attack by the progressive left. For 10 years, during which I've been on the Supreme Court, until the last election, the people of Michigan actually had a majority of rule of law justices on their state Supreme Court. The Michigan Supreme Court was the kind of court that Ronald Reagan wanted to create in Washington, but was never able to do so. The Michigan Supreme Court was one which, for example, the Wall Street Journal called one of the best in the nation, and said, the Michigan Supreme Court believes in leaving policy making to the representative branches of government and eschewing the creation of novel rights. With its traditional view of the judicial role, probably no court in the country has been less inclined to respond favorably to innovative theories allowing violent criminals to escape responsibility for their actions. Now, sadly, last election, Chief Justice Taylor was defeated in one of the most despicable, dishonest campaigns I've seen, where the left ran false sleeping judge ads. We not only lost Cliff Taylor, but we lost our rule of law majority. The new majority is what I refer to as the empathy majority. Justices Kelly, Kavanaugh, Hathaway, and Weaver comprise this new majority, and they form an activist majority on the court. Now, the best way to describe our new Chief Justice is to think of Nancy Pelosi in a black robe. She would be honored by the comparison. In the minority are the remaining veterans of the former court, Justices Corrigan, Markman, and me. Now, the new majority has moved, as I suggested, aggressively with Chief Justice Kelly at the helm. Now, if you don't have to believe me, let me introduce you to their agenda in the new Chief Justice's own words, and I quote, "We, the new majority, Kelly, Kavanaugh, Hathaway, and Weaver, will get the ship off the shoals and back on course, and we will undo a great deal of the damage that the Republican-dominated court has done." And to add to the nastiness of it, she added, "Not only will we not neglect our duties, we will not sleep on the bench." Now, in November 2010, I want to take back our court and restore a rule of law majority. To do that, we have to elect 2 rule of law justices to the Michigan Supreme Court. Now, what are the differences between an empathy court and a rule of law court? The short answer is that with a rule of law court, you can predict that the court will interpret a statute or the Constitution according to the plain meaning of their words. Today, you had a parsing of the Fifth Amendment. Not many words in there are unknowable to a layman. Now, with an empathy court, on the other hand, you never know how the law will be applied, because which party is more empathetic